Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series. The Curious Lawyer series is a fun edutainment type program. It's a walk down paths of law that you may not get in your normal everyday practice. And I call it edutainment because it's fun and interesting and it's off the beaten path. And it's the type of continuing education you can watch without being stressed out. It's not in your core practice area. You're not having to familiarize yourself with the latest trends in your particular area of law and how is it affecting your cases and all that. This is a chance to become a more well-rounded lawyer, to get exposed to and experience different areas of the law. And so in our series that I host, you will see we've done dog law. You can learn about all aspects of dog law, how our relationship with dogs intersect all aspects of lawyering. CIA law, presidential pardon law, how to commit the perfect murder is even one of the programs. So you see it all. It's fun and interesting. This is the Bill of Rights series. And so in the Curious Lawyer Bill of Rights series, you will be able to see a 1-hour program on all 10 of the Bill of Rights, all 10 of the first 10 amendments to the Constitution. And this program is designed to educate you about those 10 amendments. Super important. Some of them we deal with all the time. We hear about all the time in the press, the First Amendment, the Fourth Amendment. Some of them, like today's program on the Ninth Amendment, we never even hear about it. Barely remember it from law school. Now you get to have a little fun, interesting walk down memory lane of law school or undergrad poli-sci if you had it, or perhaps you've never even studied or thought about the Ninth Amendment. But here's what I guarantee you. At the end of this program, you'll know everything there is to know about the Ninth Amendment, and you can show up at a cocktail party and talk in an educated way to your lawyer friends about the Ninth Amendment. So let's get going. Here is the Ninth Amendment. Very simple. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights by the people. Super simple, super short. So what are we going to do with this today? Let's take a look here at the issues we're going to address. We're going to look at the substantive nature of the Ninth Amendment. We're going to talk about its historical scope and the rationale, its purpose, and the goal. What was the point of this amendment? We're going to look at the case law on the scope of it, and it's limited. And we're going to then look at the privacy zone issue. And here's a great little sort of cocktail party tidbit you can share with people, and that is that you get to use contraceptives in part because of the Ninth Amendment. Who knew? So the Ninth Amendment, it's important stuff. We're also going to look at some current issues within the Ninth Amendment jurisprudence, some novel arguments that have been made, and issues really for the amendment in contemporary society. And of course, in our new COVID age that we're in, we actually have the ability to look at COVID mandates and the Ninth Amendment and see if there's an actual intersection. And could the Ninth Amendment even have some interplay? Has it been used? Has it been litigated or advanced to deal with some of the litigation coming out of the COVID mandates in our new COVID world? So let's look again and familiarize ourselves with the Ninth Amendment and what it says. Again, remember, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So let's look now at the historical context. I want to start in the beginning. We go back to the beginning. And so let's go back to the Philadelphia Convention, and drafts of the then pending Constitution were being circulated. And criticism arose about the lack of specificity in listed freedoms and what we were going to do with the freedoms that were being put down in the Constitution or not being put down enough for the people of this new republic we were founding. And this omission was seized upon by anti-federalist pamphleteers, and they had names like the Federal Farmer or Brutus, and they circulated flyers throughout the states demanding the addition of a Bill of Rights because they feared, as anti-federalists, sort of what would happen if we didn't specifically define and provide for some rights. And so the Federalists, Madison was one of the leading Federalists, of course, defended on the basis that the principle of enumerated powers would protect people from any federal invasion or encroachment of their rights. And so if we simply have some enumerated powers, those would then limit what the federal government could do, and everything else would be reserved to the states. The anti-federalists, when they were looking at in the draft, said, well, hold on a second. That's simple enough to say but in Article 1, Section 9, there were restrictions on federal powers. And so, if that's true, that it's only a statement of a principle of enumerated powers, it raises a question of why that even exists. And so there could be some internal tension or arguments to be made down the road that would actually invalidate this very idea that you're promising us. And so they really threatened to throw out the whole draft of the Constitution and start over. And so in order to properly understand where the Ninth Amendment comes from, we see here on the next slide some more discussion about the Federalists and the Anti-Federalists. And this helps frame the language that we're going to explore shortly. So let's, in the beginning, of course, we have the Anti-Federalists who feared that the adoption of the Constitution would necessarily lead to a federal government that would seek full powers as much as possible. And with that, they feared that we have not only a federal government, the executive branch, taking as much power as it could, we also have these federal courts and another branch being created who were going to decide the meaning of the Constitution. And so between the two of them, they feared, they're going to enlarge the power of the federal government and its authority beyond all bounds conceivable. And that was their fear at the time. And so the Federalists, on the other hand, took the position that, no, look, our Constitution is going to be one that has a limited grant of powers to the federal government, and we will ensure that everything else that's not granted is reserved to the states. And that grant back, that reservation, or that recognition that we are defining enumerated powers and we're saying that the void of everything else isn't the federal government's domain, that should be a good enough promise to make you comfortable that we're not going to have some overreaching federal government that encroaches. And I think if you fast forward 200 years, everyone listening to this program can have different opinions about who was right or who was wrong on that one in terms of how things have shaken out over the last 2 centuries. But nonetheless, the compromise here in this anti-federalist versus federalist debate was that we would have a Bill of Rights that would specifically identify important protected rights and as well as freedom of speech, freedom against unlawful searches and seizures, right? Those specifically enumerated rights, as well as all of that, would have this amendment that would address some of these concerns being debated between the anti-federalists and the federalists, and would make crystal clear that any failure to list specific rights did not by default effect a transfer of those unenumerated, unlisted, unidentified rights. It would not affect a transfer of those rights into the hands of the federal government. And that ultimate compromise is seen in the Ninth Amendment and what ultimately became the Ninth Amendment. So as we're still in the beginning, let's then talk about this compromise and this Ninth Amendment. So we then start out with proposals for an amendment that was going to sort of address this. And some of the important points that form the backdrop to the Ninth Amendment today is that every single proposed version of the Ninth Amendment contained some sort of language in it that detailed the interpretation or the construction of the Constitution. And if you stop and think about it, it's really a fascinating amendment. Go back and read the Bill of Rights. It's really fascinating in the sense that it's really the only part of the Constitution that functions in that way in terms of providing a template or a mechanism for how one interprets or construes the language in this document, as opposed to just reading it and then resorting to some principles of construction. It's almost like a legend or a key in that sense. And every proposed version had that in the beginning. Now, here we have Madison's initial draft, and here's a quote from it. "The exceptions here or elsewhere in the Constitution made in favor of particular rights shall not be so construed as to diminish the just importance of other rights retained by the people, or as to enlarge the powers delegated by the Constitution, but either as actual limitations of such powers or as inserted merely for greater caution. The powers not delegated by this Constitution, not prohibited by it to the states, are reserved to the states respectively." And so what the point of this language was from Madison was this idea that we are going to prevent both the implied diminishment of other rights and the implied enlargement of enumerated federal powers. We're going to prohibit both of those with this kind of fencing mechanism. And the Ninth Amendment's proposed language was serving that goal. And so ultimately it landed on the Ninth Amendment that we have, that we've quoted now for you in a couple slides, and I'm not going to put it up again, but you can pull it up on Google real quick if you want to have that next to you as you continue listening to the program, if you want to see the language at all times. But that's what ultimately culminated in this historical sort of back and forth in ultimately then the Ninth Amendment. And so one of the fascinating sort of sidebars to history here is that we actually have some very interesting historical sort of, I won't call it historical evidence on interpretation because that's obviously a contentious sort of debated concept and idea, and we're here for just fun educational purposes to get to the Ninth Amendment. But there's this fascinating speech that Madison actually gave on the first Bank of the United States when the law was put in there to be enacted. And what's particularly fascinating about this, just frankly for all of you as listeners from a historical perspective, is Madison's speech on the first Bank of the United States actually sheds light on at least his interpretation at that time of the Ninth Amendment and what it was doing. And why it's particularly interesting, I guess, just kind of for fun, is that it was really lost or fully ignored to legal historians and lawyers and the bar until 1989, when there was a book by Randy Barnett, a law professor, that really addressed this speech that Madison gave with respect to the First Bank of the United States Act that was then pending, and recognized that that speech had really some particular import and could shed a lot of light on this sort of amendment, the Ninth Amendment, that no one barely even knows or talks about or never shows up in litigation. And so as we stop and pause here to go back to the first Bank of the United States, let's talk about what the issue was. And so the issue at the time was that there was a proposal to create a national bank. And the Secretary of the Treasury, Alexander Hamilton, had gone to Congress with a plan to charter the first Bank of the United States. And the Senate approved the plan, and the matter was debated in the House of Representatives, and it was being debated at the same time that the ratification of the proposed Bill of Rights was actually still pending in Virginia. And that, I think, is what Professor Barnett found so interesting, because we have a Constitution that's been adopted, we've got a Senate and a House of Representatives, but the Bill of Rights is now being debated, and it's being negotiated, and it's being argued about and whatnot, and it was pending. And so at that same time, the Bank of the United States Act is going on, and there's this discussion that then happens. And so as the proposed Bill of Rights was still pending, proponents of the bank then argued that the charter was necessary and proper to advance Congress's enumerated powers to tax and regulate commerce. And so we have this Article 1, Section 8, tax regulation of commerce power, and the bank is necessary to it. That was the argument for the bank. Alexander Hamilton's argument is why we needed the bank. It was going to help us achieve that enumerated power. Now, opponents, like Thomas Jefferson, on the other hand, said that, wait. If we give that, quote, latitude of construction, it'll destroy the principle of enumerated powers in the then pending 10th Amendment. And the 9th and 10th Amendments kind of went hand in hand on some of this stuff. And watch the Curious Lawyer Bill of Rights programs on the 10th Amendment, and you'll learn more about the 10th Amendment. But for today, we're talking about the 9th Amendment. And he was concerned that this would show the expansive power of the federal government. So Madison gives a speech that talks about the 9th Amendment and the 10th Amendment in terms of how those pending amendments really were working and what they were meaning, and why all of this mattered, and how the Bank of the United States could fit within this. And so what he said is ultimately that the federal government is one of limited enumerated powers. If Congress has the power to incorporate a bank, it has to be discoverable through a proper interpretation of those powers. In Madison's speech, he also talked about how an interpretation that destroys the very characteristics of the government cannot ever be just to the people. And he said, if we have controverted cases, the meaning of the parties to an instrument, it has to be collected by reasonable evidence as a proper guide. He said, contemporary and concurrent expositions are reasonable evidence of the meaning of the parties. And some of these sounds like almost like contract construction principles, right? That we all sort of embrace every day, or even been codified in our state's contract construction codes. He also talked about how in admitting or rejecting a constructive authority, not only the degree of its incidentality to an express authority is to be regarded, but the degree of its importance also, since on this will depend the probability or improbability of its being left to construction. Kind of a quantitative analysis, if you will. So in fine, he said, if the power were in the Constitution, the immediate exercise of it cannot be essential. If not there, the exercise of it involves the guilt of usurpation and establishes a precedent of interpretation, leveling all the barriers which limit the powers of the general government and protect those of the state's government. And so those are sort of the pole stars that Madison was talking about. And on this next slide, you have here a quote, and this is from the Lost Original Meaning of the Ninth Amendment article, and this is in a Texas Law Review of the citation down there, but this is the quote. The federal government is one of limited enumerated power. All non-delegated powers are reserved to the states. Unduly broad interpretations of these enumerated powers would destroy this principle by allowing the government to invade areas of law reserved to the states. Important powers like those exercised by the Bank Bill are not appropriately derived by implication, but require enumeration. The state conventions that ratified the Constitution had been promised that federal power would not receive this kind of latitudinous interpretation, and several states made the adoption of a rule rejecting this kind of interpretation a condition of their ratifying the Constitution. Although implied in the original Constitution, an express rule against latitudinarian constructions found its ultimate expression in the Ninth Amendment. That's a kind of a fascinating quote here that kind of we can take from this law review to kind of illuminate what Madison was talking about. And really by this, what Madison ultimately meant is that the more significant a power that the federal government has, the less likely it was to have escaped the framers of the Constitution. And so if it's not expressly listed in the Constitution, probably the omission was intentional. And so this, you can see, ultimately is creating the headwinds here on what was the Ninth Amendment about and what are the competing interpretations that we could have of it? You know, what is its structural function that I talk about here on our next slide? And so let's look at this. What's the purpose then of this Ninth Amendment in terms of what it was doing? And what we have is one approach is to look at it and say it's simply a substantive policy reflection that the actual rights protected in the Constitution and the Ninth Amendment functions as almost a legend or a key, right, a code on how you interpret the Constitution in general. And that is, it's really the only amendment that actually textually describes how to engage in a construction or interpretation of the Constitution. Now, the framers, of course, were well aware of universal human rights, and they talked about it, natural rights. They discussed natural rights at the time of the founding. And so another way to interpret the Ninth Amendment is that it's not just this structural interpretive legend, one of, defining and demarking the balance between enumerated powers of the federal government and reservation of everything else to the state and functioning as a federalism mechanism. Another interpretation of it, given its language, was that it is a statement more akin to almost a declaration of universal human rights, in that the point was that the actual existence of these rights was then in existence. They existed. People had a whole range of rights, independent of the Constitution's enumerated ones in the Bill of Rights. And those rights fully existed, fully vested. People had them at the time. This is what's known as the libertarian approach to the Ninth Amendment. Which is in distinction to the other kind of mechanism that one could understand the Ninth Amendment as really just being a federalism defining role and an interpretive guide to the Constitution, which is known as sort of the Federalist reading of the Ninth Amendment. And so this competing battle between, is the Ninth Amendment a, Federalist, do we have a Federalist reading? Do we have more of a libertarian reading? And if we have more of a libertarian reading, that then necessarily allows federal courts under Article 3 to judicially enforce those unenumerated rights, but those rights that exist, basic natural rights that the founders talked about, what we call today probably universal human rights, they would be able to be enforced. Life could be breathed into them through the Ninth Amendment because it recognized those rights as in existence belonging to the people. The Federalist reading, of course, on the other hand, would see it differently and say that this is a passive expression of the limits of federal power versus state power. And it's not a mechanism to enable courts to identify specific rights as being federally protected for people when they weren't identified elsewhere in the Bill of Rights, right? And so those are the competing interpretations that come out of this history we've now explored and discussed in terms of the ratification, the anti-federalist and federalist debate, and then even Madison's speech about all of this when the Bank of the United States was pending, which sheds light on sort of what was the Bank of the United States doing, and maybe his interpretation of the Ninth Amendment, as we saw there, was one more that fell on the non-libertarian side, perhaps, of this debate. On our slide here, let's unpackage a little bit more, before we start getting into some of the case law, the libertarian approach. The libertarian approach to the Ninth Amendment creates the idea of some sort of enforceable presumption of liberty that limits the interpretation of federal power in order to protect unenumerated natural rights that exist, those quote unquote other rights. And therefore, you would look at the Ninth Amendment as acknowledging the existence of those core natural rights vis-a-vis the federal government's taking or encroachment. And that viewpoint then would see the Ninth Amendment as really reflecting the founders' intent to fundamentally protect the existence of those individual natural rights, and that they were in existence and they are susceptible to protection and enforcement, and the Article III courts can then enforce them and protect them using the power of the court, obviously. Now, the critique to this approach, and I would recommend, it's a fantastic read, but if you go to, or it's a very interesting read at least, if you go to Randy Barnett's Restoring the Lost Constitution, The Presumption of Liberty, it's a fascinating exposition that involves the Ninth Amendment and these different approaches in terms of how we can look at the historical record and how we can have this sort of genuinely fun debate in modern society about where we stand and where we are on these issues. And these obviously issues that we're discussing today are very similar to all the discussions we all had in law school about substantive due process, and I'm sure a lot of it sounds very familiar in terms of the debates that have animated the interpretation of the Fifth and 14th Amendments due process clause. And substantive due process, arguments and analyses versus limits on that are echoes, at least, or strong analogies to this libertarian and federalist approach. But nonetheless, the critique to the libertarian approach of interpreting the Ninth Amendment is that it really fails to give enough credit to the founders' concerns about separation of powers and about the federalism structure of the Constitution that was seeking to really deny any federal rights or powers absent an express statement. And so what the critique really is that if the Ninth Amendment allowed federal courts to breathe life into a whole manner of rights that weren't listed in the first 8 amendments and give federal protection to them so they existed with full federal protection, that undoes this idea of state-federal government balance. And the whole point of what was going on really was to say other rights belong to the states, and those states get to decide if you have those rights or not. And if we're going to allow the federal courts to decide if you have them, we've now altered that federalism balance. And so that's sort of the fundamental critique to the libertarian approach. Let's go to our next slide, where we will look at the federalist approach. The federalist approach reads the Ninth Amendment in pari materia with the 10th Amendment, and both clauses are fundamentally understood as simply maintaining a balance of state and federal power. They are federalism, structural federalism principles that were enumerated to demark the line between all federal encroachment of rights, not just the executive, but the federal courts too, agencies, whatever aspect or whatever cloak of the federal government they wear. It's a federalism principle, and it's a limitation that no one else in the federal government can tread on this terrain. It's for the states to tread on all terrain. And so in that sense, the federalist approach to the interpretation of the Ninth Amendment sees it really as a passive provision, and it doesn't justify then, if it's a passive provision of like a structural interpretation or a legend or a key to interpreting the Constitution, if that's how it is, it really wouldn't then justify, in their viewpoint, federal judicial intervention because that would be shifting that balance in a way that's wrong. It's become now a substantive rights guarantee that it wasn't functioning to do. And so that reflects the idea that enumerated powers are the sum total of what the federal government can do, and anything that's not enumerated, 100% just doesn't exist in any federal corner, and it's for the states to go do what they want to do or not do or limit or not limit or whatever, right? And so in that sense, it can also be seen, it's not entirely passive, right? It's active in the sense that it does act to actually stop the federal government encroaching on states in some respect. But nonetheless, that's sort of the federalist approach. Now, the critique of this approach, of course, it's the flip side, right? It's the libertarian approach. But the major critique that exists in the literature and the academic debate, and then that will, percolate up into the limited case law we're about to talk about, is that this approach doesn't really fully appreciate the founders' belief in natural rights and that idea that people possessed, humans, individuals, possessed a whole range of natural rights. In other words, they weren't just saying anything not listed in the federal government, a state gets to decide whether you have it or not. And if the state says you don't have it, well, then you don't have it. That wasn't what was going on. They actually believed in this concept of natural rights. And so that's the major critique to it in terms of finding what is the common ground and what's the harmony between the two. So now, let's get going. We're going to look at some Supreme Court interpretations and some lower court cases too. But there are, first of all, very, very few Supreme Court cases on interpreting the Ninth Amendment. And there's really very few circuit court cases, first, second, third, fourth, ninth, you name it, of legitimate case law even dealing with it too. It's almost a non-existent amendment as a tool for a lawyer in substantive litigation. And so we're going to look at a few Supreme Court cases and just sort of look at them through the prism of the Ninth Amendment. And we'll start with Calder versus Bull. And then we're going to go on to United Public Workers versus Mitchell in the 20th century and Griswold in the 20th century. Before we go to those three cases, though, I want to have a quick sidebar. And this is, does the Ninth Amendment apply to the states? How does that work? You remember that whole thing about the incorporation doctrine where once the 14th Amendment was adopted, the process of incorporation was used to say that the Bill of Rights weren't just applicable to the federal government, they were now applicable to the states. And so the idea, if you remember from law school on this cool incorporation doctrine that we all learned about, was that the protections of the Constitution's amendments, the first 10, the Bill of Rights, that had applied only to the federal government, but not the states' governments, did apply to the states by way of the enactment of the 14th Amendment's due process clause that incorporated those pre-existing amendments and made them applicable to state governments, the way the 14th Amendment due process clause was applicable to state governments. And so the basic test that the Supreme Court has used to address this is the idea that fundamental rights rooted in the tradition and conscience of our people, and thus things that are implicit in the concept of order, liberty, are applied to states via the 14th Amendment. And that kind of quotation or that basic test and rule comes from Griswold, which we will talk about shortly. And it comes from Griswold at 381 U.S. at page 499. And so, really, all of the aspects of the Bill of Rights have been incorporated and made applicable to the states, almost all, except for a couple. And one of them that's never been incorporated and made applicable to the states is the Ninth Amendment, where we are today. And so, it is what it is. Let's take a look then at the 1798 case of Calder v. Bull. And it doesn't actually expressly mention the Ninth Amendment, but it's a good case to look at because it deals with some of these structural headwinds in terms of enumerated powers, natural rights, who has what power. And so we can look at Calder v. Bull and understand a Ninth Amendment overlay on it to help illuminate some ideas about the Ninth Amendment. And so this case is reported at 3 U.S. Dallas was a reporter, 386, and it's from 1798, one of the earliest cases out of the Supreme Court, of course. We all remember it from law school, or not. But nonetheless, I'm going to tell you what it's about in case you don't remember. It was about the Connecticut legislature, which had granted a new trial in a probate case. Kind of a boring thing, right? Probate case, someone loses, they ask for a new trial, Connecticut legislature grants a new trial by way of some legislative act. The plaintiff said that that legislative enactment from Connecticut violated the ex post facto clause of the federal Constitution. Now, that's kind of just the simple dispute that led to Calder v. Bull and the case working its way up to the Supreme Court. And the case, as I mentioned, it doesn't mention the Ninth Amendment, but this case can be seen as a very early incantation of natural rights existing within our legal framework and the understanding of the founders and the original justices on the Supreme Court. And the idea that natural rights law is just not incompatible per se with state autonomy and the balance of federalism, and that it does exist. And so here you have a quote from Justice Chase, his opinion in Calder v. Bull. Quote, "It appears to me a self-evident proposition that the several state legislatures retain all the powers of legislation delegated to them by the state constitutions, which are not expressly taken away by the Constitution of the United States. The establishing courts of justice, the appointments of judges, and the making regulations for the administration of justice within each state, according to its laws, on all subjects not entrusted to the federal government, appears to me to be the peculiar and exclusive province and duty of the state legislatures. All the powers delegated by the people of the United States to the federal government are defined, and no constructive powers can be exercised by it." And so that kind of becomes a structural case that's discussed in academic literature that lets you sort of see this federalism, anti-federalism approach, or federalist Ninth Amendment interpretation versus libertarian interpretation in terms of the retention of powers to the state governments. Anyway, that's Calder v. Bull. It doesn't talk about it, but it is a stop on the way to looking at the Ninth Amendment. That brings us to 1947, where we actually have the Ninth Amendment discussed. And in 1947, we have the case of United Public Workers versus Mitchell. It's reported at 300 U.S. 75. And this case involved the following situation. We had the Hatch Act, which was enacted by Congress, and the Hatch Act forbade federal employees to take, quote, any active part in political management or in political campaigns, end quote. And so the situation then involved a set of employees of the executive branch of the federal government who had engaged in political campaigns and political activity. And they became plaintiffs in a lawsuit along with a union of such federal employees. And those employees of the executive branch who had engaged in political campaign behavior or political management of campaigns sued to seek an injunction enjoining the validity of the Hatch Act. And they're in federal court, of course. And they argued that fundamentally the basic argument was that their free time is theirs. You know, when I'm not on the clock of the federal government, I have every right to go engage in whatever political activities I want, and I can do all the political, campaigning and management of campaigns that I want. And they specifically argued to the U.S. Supreme Court ultimately that their rights to engage in political exercise were fully reserved to them by the Ninth Amendment. They weren't somehow only limited to whatever the First Amendment rights are, but they were fully reserved to them by the Ninth Amendment to engage in political exercise, political activity, campaign management, political campaigning, picketing, going door to door, whatever it is, you name it, right? And here is what the U.S. Supreme Court said in its decision, quote, "We accept appellant's contention that the nature of political rights reserved to the people by the Ninth and Tenth Amendments are involved." And that's an important statement, right, from the U.S. Supreme Court. One of the first times, really, it starts showing up in case law that the recognition that their political rights, these individual union members and individual plaintiffs' rights to engage in politicking, their personal political rights, were fully reserved to them by the Ninth Amendment. Now, what the Supreme Court then said a little bit later, ... because there's always a ... right, in the law, of course, was, of course, it is accepted constitutional doctrine that these fundamental human rights are not absolutes. And so this is a very, very important point that comes out of this case that's more in line in some sense with that libertarian approach we talked about, that people are endowed with their individual, personal, fundamental human rights that they have, that they can press and they can enforce via the Ninth Amendment. Now, what the court also said is that those rights are not absolute. And so what the court ultimately held here was that the federal statutory enactment, this Hatch Act that had been enacted and came into collision with those natural fundamental rights, those human rights, in terms of limiting their ability to be poll workers, that Hatch Act was acceptable as a form of a reasonable limitation imposed in order to serve federal interests. And so it effectively was some sort of rational basis review or reasonable basis review that was applied to the Hatch Act. And this practically is very important for two reasons. Number one, it was a recognition that these unenumerated rights are possessed by people as rights, these natural rights we have. Nonetheless, they weren't absolute. And so the federal government can nonetheless, via statutory enactment, encroach on those rights if it has a really, if it has a basis to do it. And here, it didn't even really hold that it was a hyper-compelling reason, because it really applied some form of what you'd call rational basis review or reasonable review to the government's ability to limit the right, and just said, look, it's a reasonable thing for the government to do. And so what happened ultimately was we have this recognition of the right, but nonetheless, we also have this doctrine, as we all know about, strict scrutiny, intermediate scrutiny, rational basis type review, and the lowest form was kind of applied to this non-enumerated fundamental human right, in terms of limiting it. And so the right's there, but it can be taken away, right? That's kind of the sum total of the case, but it's an important stop along the way. Now, let's move forward where we may have the chance to see the high water mark of Ninth Amendment jurisprudence. And this is in the context of the right of privacy. And if you want to learn more about the right of privacy, go see our Curious Lawyer programs devoted entirely to privacy. Fun area. And here's where we have the Supreme Court mentioning it and addressing it. And this really ultimately opens the door to new expansive ideas for the reach of the Ninth Amendment along the lines of the libertarian view to protect and enshrine these fundamental rights in the realm of privacy. And so we, of course, now get to talk about Griswold. And so we're going to look at Griswold v. Connecticut, 38 U.S. 479, 1965 case, one of the high watermark cases, you could say, for the libertarian view coming out of the Warren Court. And here this case involves the defendants, who were a medical doctor and a director of a clinic who had been convicted in Connecticut. We're in Connecticut again. Like the original Calder case, now we're in Connecticut for Griswold. But nonetheless, there's a Connecticut general statute that allowed the conviction of medical doctors or directors of medical clinics who gave birth control devices to married couples. And so, in other words, doctor gives married couple a birth control device, illegal under Connecticut state law, you get busted, you get a ticket, go to jail, whatever, right? It's a violation of the law. And so the doctors said that this law violated the 14th Amendment, and we have rights. We should be able to prescribe birth control to married people, and you can't do it. And nonetheless, they lost. They were convicted. The appellate court affirmed their conviction. The Connecticut Supreme Court affirmed their convictions, and they went up on a cert petition to the U.S. Supreme Court. And part of their argument to the U.S. Supreme Court involved not just the 14th Amendment, but violation of their Ninth Amendment right to privacy, and what was framed then as a Ninth Amendment right to privacy. And so here's the issue, and this is a quote from the case. The present case then concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. And it concerns a law which, in forbidding the use of contraceptives rather than regulating their manufacture or sale, seeks to achieve its goals by means having a maximum destructive impact upon that relationship. Now what we're going to do is have a fun sidebar. You're going to listen for the next 6 minutes or so to this actual clip from the actual oral argument of the Griswold case in the U.S. Supreme Court. It's a great 6-minute or so clip to actually listen to the questions coming from the justices and the arguments of the lawyers representing Connecticut and representing the plaintiffs in terms of what they perceived as being the state's interest that could be advocated to either justify encroaching on what is a right of privacy or not justify on the right of privacy. So let's take a listen to this. It's kind of an incredible opportunity that we can actually even, we have a recording of it, so we're lucky. So here we go.
Mr. Clark, what you're touching on now leads me to ask, what is the purpose of this legislation in Connecticut? Your basic argument in your brief, and so far in your oral argument, is that this is well within the so-called police power of the state of Connecticut. And what is its purpose?
Well, if Your Honor, please, I think its purpose is
to increase the population of Connecticut, right, or to impair its decrease, or is it what?
If Your Honor, please, I do not hold that it is to increase the population of Connecticut. I don't think that this is we could make this claim valid.
So what is it? What is the purpose?
I think it's to reduce the chances of immorality, if Your Honor, please, and I use the words immorality here in a broad sense. That is, in one way, to act as a deterrent to sexual intercourse outside of the marital relationship.
Well, the trouble with that argument is that on this record, this involves only married women.
That is correct, Your Honor.
So how can you make that argument?
Well, if Your Honor, please, I think that on this record, that the statute is a valid exercise of police power.
Well, for what purpose?
And if Your Honor, please, on this record, that there is a distinction, and there has to be a distinction between birth control and the use of contraceptives. That is to say that all contraceptives involve birth control. But in order to practice so-called birth control, one does not have to use contraceptives. And that the state is able to take this position and take this distinction, that there are, if it be said, well, should married people be allowed to use these devices?
Yeah.
Is not the state going too far? I think the state can answer to that there are other methods available to married people.
Well, now, for what purpose under its police power? Assuming we're dealing now with married couples.
Well, if Your Honor, please, going back, Connecticut in the Nelson case cited the Byrne case in New York. And one of the reasons cited by the Connecticut court and the Byrne case was that it would not be, as a matter of fact, it would not be improper for the legislature to consider that Connecticut, as any state, has a right to look out for its own continuation. This is the population argument. I personally am not too happy with it, but
well, what argument are you happy with?
I think, if Your Honor, please, the only argument that we can honestly say is that this is a question of pure power.
Well, do you suppose the state of Connecticut could prevent marriage?
I think the state of Connecticut could prevent marriage on certain people, certain groups. Yes, if Your Honor, please. Between idiots, say, or age in marriage, I think, Your Honor, please, that...
But surely you'll agree with me they couldn't... I should think you'd agree with me that the state of Connecticut should say there'll be no marriages contracted in this state. Be no sexual intercourse of any kind, married or unmarried.
I agree with you.
Well, now, what is the police power purpose of Connecticut in telling married people, two people who are married to each other, that they cannot use contraceptives?
Well, I think, if Your Honor, please, it's to preserve...
what kind of morality? What moral purpose is
well,
that?
If Your Honor, please, it is not unheard of that the use of contraceptives themselves would be immoral. Certainly, this is a view that has been prevalent in history right up to the last few years in most groups. In Connecticut, I'm citing the brief of our opponents in one instance of the number of Catholics and Orthodox Jews in the state. If you were just to put it on a numerical basis,
well, you'd have quite a different case if the state of Connecticut compelled their all married couples to use them. That's when you'd run into the argument you're now making, that this violates the religious precepts and beliefs of certain groups.
This is true, but if Your Honor, please, it also would be more difficult for the state to control the result of what you might call dissolute action. That is, fornication and adultery. That's what it's there.
Well, I thought you and I had agreed that isn't involved here. We're dealing here with, by definition, and on this record, with advice and the furnishing of devices to married women who ask for such advice.
Well, Your Honor, please, I think what we have here, that is true. We have here a center being used, and the witnesses that the state used in this case were, in fact, 3 married women.
Mr. Clark, inquiry, on page 15 of your brief, I don't know that I agree, but if you might provide an answer by reading what your court said in State versus Nelson. Doesn't sound like a very lofty attribution to married people, but that's the reason your court assigned. Page 15, State versus Nelson. You look at the next to the last paragraph.
Your Honor, please, that's what I was trying to get out, and I must say that I did it rather poorly.
That is the reason your state, I take it, assigns that morals are involved.
That is correct, if Your Honor, please. The court held in Nelson, it, meaning the legislature, was not precluded from considering that not all married people were immune from temptations or inclinations to extramarital indulgence. And I think, if Your Honor, please.
That is the moral ground, then, upon which presumably your court has sustained this legislation under the police power.
I think it is.
That's the ground on which you're relying.
That is correct.
Here we have on the next slide, Griswold v. Connecticut's zone of privacy language. And this is an important quote from the case. The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. The right of association contained in the penumbra of the First Amendment is one, as we have seen. The Third Amendment, in its prohibition against the quartering of soldiers in any house in time of peace without the consent of the owner, is another facet of that privacy. The Fourth Amendment explicitly affirms the, quote, right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, end quote. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. And here's the important part for our program today. The Supreme Court continued, the Ninth Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And so this then gets us, we'll go to the next slide, to how the court then took the Ninth Amendment and used it as part of its constructive analysis to identify whether there is a privacy right that trumps Connecticut law, which privacy right is possessed by the people, which a federal court can enforce notwithstanding what a state says. Here's what the court asked. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. In other words, those ideas of privacy about our intimate marital relationship and what we do in the bedroom, or our intimate sexual relationships and what we do in the bedroom and who we do it with. The idea that the state can muck around in there, anathema to a free society, right? That's what the Supreme Court was saying in Griswold there. And they went on to say, quote, we deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse, hopefully enduring, and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. And so based on this rationale, Griswold versus Connecticut reversed and vacated those convictions and struck down that Connecticut law. And so what Griswold then stands for is the idea that this right to privacy that was possessed by the plaintiffs in Griswold, by us as people in our bedrooms and what we're doing, right? It's in part rooted in the Ninth Amendment. It's not simply a question, a federalism question of, well, there's nothing in the Constitution about contraceptives or regulating them, and so therefore the federal government, we just treat it as a federalism principle. If the state wants to regulate it, so be it. The state can regulate it, right? The pure federalism interpretation of the Ninth Amendment would say that's okay. The libertarian approach of the Ninth Amendment that was more grounded in the idea that there are fundamental human rights that even if not listed in the first 8 amendments, people are possessed of them, and it's not just up to a state to get to decide what your rights are, right? We're possessed of certain rights. That rationale here was adopted by Griswold, and you see it there in its language. We deal with a right of privacy older than the Bill of Rights, older than the political parties, older than our school system, right? It's this idea that our right to marriage and what we can do in our marriage, in our bedroom, and use contraception or not use contraception, right? We're possessed of it. It's not just a question of the states getting to decide if we have the right or not. We own it. And this kind of comports then, ultimately, and this is why I can say this is the high water mark of sort of Ninth Amendment jurisprudence for the libertarian view, is it reflects the idea that those rights are profoundly important, they exist, that the Ninth Amendment is not just a federalism shifting passive tool or an interpretive tool. It's actually a mechanism, a constitutional mechanism that can enable the enforcement in federal court of actual rights, even though they're not listed perhaps per se in the first 8 amendments, although the penumbras of them were all so there. It was a fundamental human right. And that's why it's sort of very important, this language, in terms of recognizing then that that state statute falls. And so if we juxtapose for a second Griswold to the prior case, we see that each of the cases recognized that there were these rights, not per se listed in the Constitution, but within the penumbras of them perhaps, an old-rooted fundamental rights, politicking and being allowed to be involved in politicking, and using contraception or not, or how you have sex with your loved one, to put it more crudely, right? But those rights existed. Griswold, of course, struck down the Connecticut restraint on those rights. And our prior case allowed a federal restriction on those rights because it served some sort of rational basis. And so when we look, that's why that oral argument clip you just listened to was so particularly fascinating, the push and the push and the push by the Supreme Court justice to understand what on earth really is your real interest in kind of mucking around in the bedroom, right? And getting to the point that there's just not a good reason to do it. So in that sense, Griswold versus Connecticut becomes one of the high water marks for this battle. This battle, of course, is particularly important because it continues today, and now we have a shifting Supreme Court, as we all know about in the press, with all the changing makeup on the Supreme Court. And one of the big questions that now stands is, will Griswold v. Connecticut at some point get undone? And if it does, it will be because the new makeup of the court has an interpretation of the Ninth Amendment and an interpretation of it as being more of a federalism key, and that therefore it may adopt a different standard of review or mechanism of reviewing these restrictions on those rights, and even the ability to say those rights exist in federal court if you want to adopt an extreme federalism view of the Ninth Amendment. Other important language that has become very important in subsequent cases, of course, is Justice Goldberg's concurrence in this case, because Justice Goldberg said, the language and history of the Ninth Amendment reveals that the framers of the Constitution believed that there are additional fundamental rights protected from government infringement which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments. And so that was joined by Warren and Brennan, but really it's worth reading again and looking at twice because it gets at this core question that we've been debating about what is the function and how does one see the Ninth Amendment? Because what he is saying is that the framers understood that we're listing 8 fundamental rights, or more than 8 perhaps, but we're listing all the rights in the first 8 amendments, however many rights you find in those 8 amendments. But the point being, there are more than those 8. And the framers knew that there were more and recognized that those additional fundamental rights can't be, interfered with by government, state or federal. And they existed along with them. And that's what the Ninth Amendment is saying, is that we've said 8, but oh my gosh, there's a whole bunch more, and they're as powerful and they can be enforced in federal court. That concurrence in terms of that, what we could say is now on the other side of it, right? The extreme libertarian view of the Ninth Amendment is that interpretation that's particularly important and is the fracture line for today's debates in our modern 21st century society about all manner of these issues. And so this is why in the future cocktail parties, you're going to have a lot of fun being able to talk about these views of the Ninth Amendment, because everyone's going to be asking you, is the new Supreme Court going to undo, Griswold? Is it going to undo all the other rights that have been protected, in the more recent cases, Lawrence and all these other cases? And you'll get to say, well, depends upon how it interprets these provisions. Now, let's shift for a second to what we can, realpolitik is sort of the known doctrine of political philosophy. Let's talk about real legal politik. And this is the bottom line reality. You as a litigator now want to go out and say, oh, great, I've got a client, got a problem. I'm going to bring a Ninth Amendment claim. Let's look at other cases for privacy rights or other rights that are fundamental but perhaps not listed, and how it's shaped up when people have tried to press these cases in federal court. And the bottom line here is that there is not a lot of success. So other than the scant place you may find it in the Supreme Court cases we just saw, it turns out if you try to press these claims, there's really not much traction you can ever get in the trial courts, because that Justice Goldberg type concurrence, extreme version of the libertarian view just hasn't found a footing in application in other rights contexts by and large. There are some, but by and large. So let's take a look at where it's just not going to work, and these are some fun, interesting cases where people have tried. And so we have a situation where, in the first case, Strandberg versus the City of Helena, this is coming out of the Ninth Circuit. It's reported at 791 F. 2nd, 744, and it's from the Ninth Circuit in 1986. And so what we have here is a situation where the plaintiff sues the city and some government employees. And the plaintiff was upset and claimed injuries on the basis that the city employees had issued defamatory statements. Basically, the city employees had said that the plaintiffs had committed some criminal and unlawful acts, and the plaintiff said, we never committed any criminal or unlawful acts, and you as city officials saying that defames and injures us. So it's kind of like your defamation type concept, right? And so as well as bringing sort of those types of claims, they file a federal court civil rights lawsuit claiming 1983 civil rights violations, and they contended that the Ninth Amendment protected their right to be free from kind of unfair, defamatory, inappropriate statements. And the Ninth Circuit rejected that. And the Ninth Circuit said, the Ninth Amendment has never been recognized as independently securing any constitutional rights for purpose is of pursuing a civil rights claim. Like, in other words, you can't use the Ninth Amendment to then go on a federal civil rights claim to get money from the city. And so it was rejected. And so there's an example of one saying, don't I have some sort of or fundamental right that may not be, it's non-listed in the 8 amendments, but I got that right. It's like these other rights. I want to do it. Ninth Circuit says, no, you can't. You unhappy about defamation, go to defamation law, in other words. And you have tort remedies, and civil tort law exists for that. You don't get to sort of constitutionalize your defamation claim via the Ninth Amendment. Another one comes up in kind of more in the context of the Second Amendment, you could think, and involves guns. And so this case is Young versus Hawaii. It's reported at 548 F sub 2nd, 1151, and you can find the specific page site that we're looking at here on 1168. It's coming from the District of Hawaii in 2008. And what it's quoting is a case from the Ninth Circuit, and the case it quotes, which is a similar kind of gun-related case, is San Diego County Gun Rights Committee versus Reno. And that was reported at 98 F 3rd, 1121 at page 1125, and it comes out of the Ninth Circuit in 1996. But nonetheless, let's take a look at Young versus Hawaii, which is the more recent case building upon San Diego County Gun Rights versus Reno. And so here's what happened in Young versus Hawaii out in the awesome state of Hawaii. Plaintiff wanted to have a license to carry a weapon and wanted to have a license. And the state of Hawaii said, nope, you don't have a license to carry a weapon. That violates Hawaii state law. And so this plaintiff wasn't allowed to have a weapon. And so the plaintiff then said that I have some right to bear arms. And under the Second Amendment, but also, the plaintiff asserted that this Hawaii state law is denying my just fundamental right to possess, carry a weapon and whatnot. And that violates my Ninth Amendment rights. The Ninth Amendment is the basis for my right to have my weapon, my gun. And Young versus Hawaii says, quoting the San Diego County Gun Rights case, that we join our sister circuits in holding that the Ninth Amendment does not encompass an unenumerated, fundamental individual right to bear firearms. And so this idea that the Ninth Amendment could be used to further enlarge whatever the Second Amendment says, go watch our Curious Lawyer Bill of Rights program on the Second Amendment for that one. But what it does is it shows that the courts have rejected the idea that there could be some pre-existing fundamental right for an individual to bear firearms that would find refuge in the Ninth Amendment, unlike there being, of course, a fundamental right of an individual to use contraception or however they engage in sex in their bedroom that is free from regulation from a state or federal government. And so, again, it's a massive curtailment of what the Ninth Amendment could be or could be argued to be in terms of divining what those fundamental but unenumerated individual liberty rights are. Now, the final case we have involves very sad fact pattern, but this involves a situation of someone's son got arrested and detained and was arrested by the police, had an interaction with the police, gets arrested, gets taken out of jail. Literally 30 minutes after being checked into the jail, hangs himself and dies, commits suicide in the jail. And so the parents sued the police and the city and the officials for that loss, and they tried to ground their claim in terms of the damage to them by the failure to protect their son in custody, which led to his suicide, and this idea that there was a duty to sort of take better steps to protect them. They then asserted a Ninth Amendment claim, and it was rejected. And at this point, you can see I'm becoming a broken wheel. Regardless of the nature of the type of claim that you try to bring, it is very hard to come up with a claim that can shoehorn into the Ninth Amendment. And there you see our case citation for the case. But that's the real legal politique, so to speak, of cases that fail to find protection under the Ninth Amendment. Now let's take a quick look and a little sidebar here on modern Ninth Amendment arguments that could be percolating in our very, very current day and age, the post-COVID world. And these are some arguments that could have relevance to COVID and COVID vaccine rules or COVID mandate rules and the like. And so now we're going to look at the National Federation of Independent Businesses versus the Department of Labor. Big case in late 2021, went to the U.S. Supreme Court, January 2022, and it's a COVID litigation case. We can call it part of the COVID litigation world. And this involved OSHA's emergency testing standards that were created and then imposed on all businesses over 100 employees. And it's what we all colloquially obviously know from conventional press. It's the mandate case. It's about sort of this idea that there's a mandate on all businesses over 100 employees that there have to be emergency COVID mandating testing standards used. And so the issue is being litigated, obviously, and it's not a core Ninth Amendment case as it was being litigated in the trial court and the appellate courts, but now the case goes to the U.S. Supreme Court. And in one of our amicus briefs of Torrey Says LLC, one of the parties on an amicus brief, and it's a news outlet. Torrey Says LLC is a news outlet, it's an online community involved, as they discussed, and their sort of premise of this entity is that it's an education center, it's a news outlet, it's an online community dealing with education and the Constitution in particular. And they argued that the U.S. Supreme Court should take the case and address it on Ninth Amendment grounds. And here was their argument. Their argument, and this is a quote from their amicus brief of Torrey Says, because no express constitutional authority exists for the federal government to mandate the vaccine and testing regime, which has been wrought with controversy from its inception, businesses retain the fundamental right to determine whether to require employees to undergo such measures. So you can see here the Ninth Amendment being used in a slightly different way. Here what's going on is business entities are saying, hold on, there's nothing in the federal Constitution that allows the federal government to just issue some mandate rule. And if it's not there, then that right exists for businesses. It's a fundamental right for the businesses to decide if they're going to impose a mandate or not on their employees. You just can't force us to do it. And so here you see the use of the Ninth Amendment, but instead of advancing it through this pure libertarian approach, they're pushing it through the federalism prism. And they're not always mutually exclusive, obviously. And so that's kind of a fun aside in terms of where this is percolating in the Supreme Court. Now, what happened in that case on our next slide you see here? The Supreme Court granted cert, as we all know, and ultimately held that the plaintiff applicants there were entitled to a stay of the mandate rules issued by the Biden administration because fundamentally the Supreme Court said they were likely to succeed on the claim that the Department of Labor simply lacks authority to impose COVID-19 vaccine mandates. The Supreme Court did not mention the Ninth Amendment. The case is reported at 142, Supreme Court 661. It's from January 13th, 2022. So we have to wait more for the Ninth Amendment to creep into Supreme Court case law. Hopefully in some of these contentious cases that will be coming down, we will see some justices trying to work the Ninth Amendment back into our life. It's a fun amendment, and it'll give me the chance to come back with part 2 to this program. So our conclusions today as we wrap this thing up. There's a huge battle over the scope and meaning of the Ninth Amendment as an interpretive tool to the federalism structure versus an actual protector of substantive rights that can be used by federal courts to protect those rights vis-a-vis federal or state encroachment. What I think I call at least the high point, it's obviously a debatable point depending upon one's perspective, but I use it as high point because not as a sort of a qualitative statement of propriety or correctness, simply as it's the point at which the libertarian view was at its greatest peak in terms of the Ninth Amendment is the Griswold case, and we can juxtapose against that the Hatch Act case from 1947 that showed much more deferential government behavior to the interference with what would be like fundamental rights. There is, of course, the practical reality we went through, which is you want to start getting creative in your litigation practice and start framing new claims like defamation, I want to have a gun, or whatever it may be in Ninth Amendment terms. Good luck, not going to happen. And of course, in the COVID age, it's even found life again to be argued. So there you have it. Thank you for watching today's Curious Lawyer Bill of Rights program on the Ninth Amendment. Watch the other amendments so you become, or you resume your growing expertise in the Bill of Rights to the Constitution of the United States. Thank you.